Schrems, assessed whether the mechanism used by Facebook Ireland to share European data with Facebook in the US was in violation of European citizens' right to privacy. The Court of Justice ruled that while standard contractual clauses can be a legitimate means to transfer data, the Privacy Shield was not a satisfactory framework to protect the rights of individuals and therefore was invalid. In the wake of the decision, the European Data Protection Board has issued a set of recommendations on measures that supplement transfer tools to ensure the compliance with the European level of protection of personal data when transferring data to third countries. I would like to welcome today 4 distinguished speakers who will help to shed light on what this ruling means for the daily business of companies transferring data between the US and the EU. I am particularly pleased to welcome a representative from the European Data Protection Board as our first speaker. As mentioned, the European Data Protection Board has recently issued an updated set of recommendations on data transfers, and we will be pleased to hear very freshly and first-handedly from Mr. Gomez Navarro. Ignacio Gomez Navarro is legal officer in the Secretariat of the European Data Protection Board. He works on matters in relation to the Schrems II judgment and other developments in the area of security, law enforcement, and GDPR. Good morning, Mr. Gomez Navarro.
Good morning. Thank you for your invitation.
Thank you. Then I would like to warmly welcome Ms. Laura Senatori from ICT Legal. Ms. Laura Senatori is partner of ICT Legal Consulting and a fellow at the Italian Institute for Privacy. Laura is specialized in data protection law as well as technology law. Good morning, Ms. Senatori.
Good morning, everyone. We are very happy today.
Thank you, Laura. Very importantly, our third speaker is going to bring in the SME perspective. Mr. Davide Garibaldi is co-founder and CEO of End Cyber Risk, an Italian company specialized in complex project management with information security systems for Italian public bodies and private companies. He has 25 years of experience with enterprise security risk management. Moreover, he is the coordinator of Asintel's cybersecurity working group. Asintel is the National Association of ICT Enterprises in Italy and a member of the Italian Digital SME Alliance. Good morning, Mr. Garibaldi.
Good morning to everyone, and thank you for inviting me.
Good morning, thank you. Last but not least, I would like to welcome Ms. Cécile Faradin from Legitimis. Cécile Faradin is a data privacy and security consulting working for Legitimis, a German company. She has a background in international and European law and currently advises German and European companies of different sizes in various industries about data protection and information security. Cécile will be able to offer a bird's eye view of a company working with both SMEs and large players. How do SMEs cope with the obligation, and what's the balance of power vis-à-vis large players? With this short introduction, I would like to hand over to the speakers. The panel discussion will start with opening statements in the order provided in the agenda. After the panel, questions from the audience will be addressed. For the audience, please remember that you can ask your questions both in the chat and by raising your hand. We are also monitoring our social media channels for questions, where this debate is live streamed. Also, please remember that this is an informal debate and that speakers may comment in their personal capacity. So therefore, please do not attribute quotes to individual speakers without confirmation or out of context. Mr. Gomez Navarro, I would like to hand over to you now. Thank you very much.
Thank you very much, and thank you again for giving me the opportunity to be here and present the recently adopted final version of the recommendations on supplementary measures. As you rightly said at the beginning of your presentation, the Schrems II judgment, while it invalidated the Privacy Shield adequacy decision, it upheld the standard contractual clauses as a transfer tool. However, it upheld them as a generic transfer tool in itself, but while emphasizing that as a transfer tool, as a contractual tool, it always applies in a specific context. And this context in which they apply meaning in specific third country and also specific circumstances of the transfer, will determine whether the safeguards this transfer tool contain are effective or not in ensuring an essentially equivalent level of protection. Where the safeguards, these contractual safeguards found in a transfer tool such as the SCCs are not effective, then the court said that the transfer could only proceed if supplementary measures could be adopted that would ensure fill the gap in the protection and ensure that it reaches an essentially equivalent level of protection to that which is guaranteed in the European Economic Area. This was the standard. So as soon as the judgment was delivered, the EDPB set out to provide guidance to stakeholders, especially bearing in mind SMEs, fully aware of how complex it could be to implement this judgment and the practical consequences derived from it. The goal of these recommendations, the objective, has always been to assist data exporters with their evaluation of the situation, of the effectiveness of the transfer tool they are using in a specific third country and in specific in the context of a specific transfer, and also with the identification of effective supplementary measures where these are required. So as you may recall, a first version of these recommendations was published last November. A period of consultation was open during which the EDPB received over 200 contributions from many different stakeholders, including business associations, organizations in defense of the rights to privacy and data protection, and also governments. And the EDPB reviewed every single one of these contributions and revised the recommendations to publish the version which you recently saw adopted. The novelties of this new version compared with the previous one, I'll try to be as brief as possible in this respect, are mainly concentrated in what we call step 3, which is the step that is dedicated to the assessment of the situation in third countries, and mainly to the data exporter's assessment of whether the specific transfer tool that is being used can effectively ensure a level of protection essentially equivalent to that guaranteed in the EU for that specific transfer and in that specific country, taking into account the laws, of course, of the third country. This is the standing point of any legal analysis or review, the laws that may exist, but also the practices. And this is one of the main novelties that has been added to this final version of the recommendations, this emphasis on the value that the practices of the authorities in this third country concerning, for instance, the access to the data that is transferred may have in this assessment. This is something that was further emphasized in this final version in light of the contributions received from stakeholders. What does this mean in practice? This means that, and to make this even more explicit, again, in terms of style, in terms of content, the EDPB always tried to keep the needs for information of SMEs. In terms of the practical scenarios they may face, the recommendations detail 3 different scenarios in which these practices could play a special role. First, the scenario is the scenario where a third country has legislation in place that is seemingly compliant with data protection standards, with EU standards. For instance, this third country may be party to some international conventions, including Convention 108. This third country may even have a data protection legislation, but it is manifest, and this is the word manifest, it's clear that despite having this legislation, in practice, its public authorities do not comply with it or do not apply it. So, of course, in this situation, the practices of the third country authorities cannot be ignored. A data exporter cannot turn a blind eye on these practices and needs to act accordingly, either suspending the transfer or adopting adequate supplementary measures. The second scenario, so this scenario was already somehow reflected in the previous version, but it was even made more explicit. The second scenario is that situation where the data exporter wishes to transfer to a specific third country, and it seems that there's no relevant legislation applicable to the transfer. For instance, there's no legislation on surveillance measures or access to data by the authorities of this third country. Does the fact that there's no legislation mean that these practices do not take place, that there's no government access to data in this third country? Not necessarily. This is why here the analysis of the practices there may be in this country will be helpful to determine if indeed the transfer tool in the context of this specific transfer can be effective in ensuring an essentially equivalent level of protection. I keep repeating transfer tool in the context of a specific transfer because we wish to draw a clear line and clearly distinguish this assessment that the exporters will be conducted with the assessment that the European condition, the full-fledged assessment of the situation in third country that the European Commission would conduct in the framework of, in its preparation of adequacy decisions. And then the third scenario, which is a new one to these recommendations, is that scenario where we know that in the third country there is legislation that is problematic. So by problematic, we mean legislation that will directly affect that transfer, that specific transfer, and may impinge on the safeguards of the transfer tool. And at the same time, it's legislation that does not meet European standards concerning respect of the essence of the fundamental rights and the necessity, strict necessity and proportionality of the measures to pursue an objective similar to the ones we may find in the European Union, such as fight against crime or public security. This is what we define as problematic legislation. So in this case, a data exporter may see that indeed there exists a problematic legislation in the third country, but may not be that sure on whether this problematic legislation will apply to it in practice or not. It could be because the terms of this problematic legislation are very wide. For instance, problematic legislation may only apply to telecommunication service providers, and the data exporter may not be that sure of whether it falls or not under this definition of telecommunication service providers. Or it could also be because although this legislation will be formally applicable to the transfer, to the specific transfer made by the data exporter, whether to the data or to the importer itself, the data exporter may be able to demonstrate that in practice, this legislation is not applied. So these are the keywords that may summarize these new additions to the recommendations. In practice, practices, and effective, ensuring always that in the end, the transfer tool and the guarantees are effective in ensuring an essentially equivalent level of protection. In terms of what the new version of the recommendations also does, is expanding on the potential sources of information and elaborating on them that data exporters may use in their assessment, of course, in cooperation with the data importer. And one of these sources that was not contemplated before in the previous version and is contemplated in the final one is the practical experience of the data importer, for instance, concerning the request he may have received in the past from public authorities in the third country, or the absence of request, or the fact that it has not received any request in the past from public authorities. What is important to emphasize is that this source of information, the practical experience of the importer, is one among several, but cannot be the source, the only source of information on which a data exporter can rely to proceed with the transfer. This information needs to be corroborated and contrasted with other sources of information. Could be the experience of other entities in similar situations as the data importer, on whether they have received or not. And it could also be reports from independent oversight bodies, NGOs, and others that are mentioned in the next 3 of these recommendations. It's important. In the end, and this is why the terms overall assessment are used, because it's an assessment that is based on multiple sources and cannot only rely on one, such as the practical experience of the importer. Why? Because in some situations, the importer may be a newcomer, and simply by the fact that it has been in the market for a very short time, it may not have received requests for access. But it could also be, as it usually happens, that in the third country, there is what we call suppressing legislation, such as gag orders or measures under this legislation, such as gag orders, that prevent importer from disclosing to other parties, such as the data exporter, the fact that it has received requests for access, or even the fact that it has not received requests for access. So these are the main changes. One that could could be also underlined or emphasized is the fact that, although it was present in the previous version, is that making more explicit even more that problematic legislation may not only affect the data importer and impose obligations on the data importer. The problematic legislation of the third country of destination of this data may also allow its public authorities to access directly to the data while it is in transit. So this is something that, even though it does not require the intervention of the importer, may also impinge, may also affect the safeguards of the transfer tools that are being used for this transfer. And this is something that also needs to be taken into account, and that may also require the adoption by the data exporter of supplementary measures, such as end-to-end encryption, so that this data is not accessed while in transit. And I think I will stop here, not to lengthen excessively my intervention, but of course I look forward to any questions you may have on this new version of recommendations. Thank you.
Thank you very much, Mr. Gomez Navarro. It was already very interesting, and I'll have a number of questions for you, but I think I would first like to give the opportunity to the other speakers to provide their first statement, and then we go into the discussion. So I would like to hand over to Ms. Senator, and yeah, the floor is yours.
Thank you very much, and thank you again for inviting me. Thank you, Mr. Gomez, for your interesting intervention. We, as legal experts, as a law firm working with data protection with Italian companies and also international companies, our intervention today will try to give an overview of the legal framework applicable to the data transfer. As stated before, the Schrems II ruling was a very important ruling that, on one hand, invalidated the privacy shield, and on the other hand, put forth additional important requirements for using other transfer tools, such as the standard contractual clause. Furthermore, a second important step of this legal framework is that the European Commission recently published the final implementing decision adopting the modernized standard contractual clause, which actually are coherent with what the European Court of Justice stated in the Schrems II decision, and as perfectly overviewed by Mr. Gomez, then there were the final publication of the recommendation of the ADPB, which is a tool that aims at helping the data exporters in doing this assessment before transferring their personal data. As far as the Schrems II ruling is concerned, we can see three main aspects of this ruling, of this decision. The first one is the invalidation of the privacy shield, which was an adequacy decision which enabled one of the transfer tool, which enabled the transfer of personal data from European Union to the US, which was considered invalid because of some data protection law, some laws applicable in the US, which actually made ineffective the use of other transfer tools, such as the standard contractual clause. And that's the case of surveillance programs enabling access by public authorities to EU citizens' personal data for security purposes. Furthermore, another important step of this ruling, another important aspect, was that the standard contractual clause alone could not always be a sufficient tool for transfer, because whether it's actually, according to the court, the data exporter should assess whether the local legislation of the country where the data were transferred could impeach the effectiveness of the standard contractual clause, which we shall remember are an instrument of which act between the parties, which cannot bind the public authorities. And thirdly, last but not least, the court also gave an important role to the supervisory authorities, assessing that in case no supplementary measures are applied to transfer based on standard contractual clause, and in case the supervisory authorities finds that the local legislation or the practices actually impeach the application of the standard contractual clause, the supervisory authority might suspend or prohibit the transfer, which is very important in the practical context of companies transferring data. We can see a couple here in our presentation. We overviewed a couple of relevant post-Schrems II decisions of European data protection authority. So we have the Bavarian Data Protection Authority, which actually determined the unlawfulness of transfer of data by a German company working in the newsletter field, MailChimp, which is a provider that we know is very common also between the SMEs. And actually, in this decision, it was considered that no additional adequate security supplementary measures were implemented, and so the transfer was considered unlawful. And another relevant decision was that one of the Portuguese data protection authorities through Cloudflare, where more or less it was the same, but it is important to understand that both data protection authority suspended, inhibited the transfer. As far as the new standard contractual clause that have been published recently, they perfectly embed what the recommendations, the ADPB recommendations stated, and what the Schrems II ruling stated. So these new recommendations are in line with this new standard contractual clause, are in line with the GDPR, are a more flexible tool, and they can be used in 4 different modules. So from controller to controller to controller to processor, processor to processor, or processor to appointing controller. The important things in terms of when they could be used by companies and by SMEs, from the 27th of June, it is possible to use the new standard contractual clause, but it is not mandatory because there are 3 months that the companies can use to adopt this new standard contractual clause on new contracts. While as for the old contracts already signed with their providers, for example, there is a transition period of 18 months. So companies have until the 27th of December 2022 to adopt the new standard contractual clause on the old contracts. So this is very, very important. I will quickly go through this part because it was much better explained by Mr. Gomez. The most relevant thing for SMEs is to really use the recommendation given by the ADPB and follow the steps that this recommendation describe. As stated before, the first thing is which is not simple at all, is to know the transfer that a company is doing. So knowing who transfers data and where, that's the first step. The second step is identify the transfer tool one wants to use. So if it's an adequacy decision, the company will just have to make sure that this adequacy decision is always in place. Let's take, for example, the case of the UK adequacy decision, which has been published recently, but we need to make sure that the adequacy decision is always still in place. While as for the other possible transfer tools, such as the standard contractual clause, and also the binding corporate rules, they do not act in a vacuum. So the third step is most complicated one and implies a data transfer impact assessment, which is an evaluation made by the data exporter with the help of the data importer that aims at understanding the level of protection of personal data in the third country. This exercise is not simple at all. It is not simple for big companies. and it's even harder and challenging for SMEs. We know that, and that's why the only instrument that we have to help this exercise is the recommendation of the ADPB, which gives not only the possibility to use the sources of information, but the most important thing is the supplementary measure, the exemplary supplementary measure that are described in Annex 2 are a precious instrument for SMEs to understand whether the data can be transferred or not. So from a practical point of view, the steps that an SME should follow should be identifying the transfer, verifying the legal basis. In case a standard contractual clause or also binding corporate rules are chosen as transfer tool, it is still necessary to perform a data transfer impact assessment and understand whether it's necessary to implement supplementary measure to guarantee the level of protection. We suggest to proactively go towards the providers in order to start this mapping of activities and to assess the necessity of these supplementary measures, because 18 months are nothing considering the number of providers that a company can have. And of course, once this transfer are clarified and based on a transfer tool, the information notice shall describe it, the record of processing shall describe it, and the SMEs shall organize in an accountable way in order to be able to demonstrate what has been carried out to guarantee the respect of the data transfer obligation, which means also keeping trace of the evaluation made, keeping trace of the reasons why the level of protection of the third country was considered sufficient. And of course, closely monitor the situation of the third country and the situation of the transfer of the for example, by sub-processor, so which means binding also the providers to notify in case anything changes the place of transfer or the sub-processor transferring. So it is very important to state that as well. And as we were saying, the modernized standard contractual clause embed the step 3 of the recommendation in the clause 14 of the standard contractual clause, where actually it is stated that the data exporter shall evaluate the efficacy of the efficiency, the level of protection of the third country. And finally, this assessment, so the most difficult thing that shall be done by data exporter is assessing the impact of the transfer. How could this be done? So the aim of this is to evaluate, as we said, the level of protection guaranteed by the third country, also in order to understand whether supplementary measures can be helpful to guarantee an adequate level of protection. It is not, it cannot be the case. In this case, one should evaluate to suspend the transfer. These assessments shall be documented and made available upon request of the supervisory authority, and the assessment shall consider the specific circumstances of the transfer. It should consider the laws and the practices, as said by Mr. Gomez, and the practices of the third country, including, as Schrems teaches, the disclosure of data to public authorities or the authorizing access by such authorities, which can impeach and the effectiveness of the standard contractual clause, and also assess any relevant contractual, technical, or organizational safeguards that can be put in place to supplement the safeguards under the standard contractual clause. And I would stop here because I don't want to take time to other speakers. And just at the end of my intervention, I take the chance to invite all the participants to have a look at the tool that we, ICT Legal Consulting, as partners in Cyberwatching EU European project, in the context of which this webinar has been organized. We have created a tool which aims at helping the SMEs at assessing their GDPR temperature, so assessing how compliant they are to GDPR and how what things could be ameliorated or strengthened. And this tool is available online, and you can find it in the slides. The slides will be made available to all the participants, also with the links to the mentioned documents. Thank you very much.
Thank you so much, Ms. Thank you very much, Ms. Senatori. And I really appreciated also the practical approach and summarizing again what an SME should be doing. And with that, I would like to hand over to Davide Garibaldi, who is an entrepreneur and who can give us some more ideas on how SMEs see this and how this is handled in practice. So, Mr. Garibaldi, the floor is yours.
Thanks again. It's a great honor to be here with you. I wish to start from a different perspective to talk about our topic about data transfer. I wish to start from a practical point of view. Maybe that it should be considered very simple or common, but I wish to start from this practical point of view because I'm an entrepreneur and every day I deal with data to protect my customer information security systems. As you told, I am the coordinator of Asinter Cybersecurity Working Group, which aims is to sustain regulatory awareness and pre-competitive business development. One of our goals is working on challenges for me and try to answer to a growing set of questions about data protection and data transfer. I spent my last 25 years working on information security fields. And someone says that I'm expert on cybersecurity within enterprise risk management, but I prefer to say that I'm passionate about my job. I'm an Italian entrepreneur, and I live and also work in Switzerland. And before COVID, I used to travel a lot all over Europe for doing my job, seeing different approaches and feelings about data protection and information security. Of course, I wish to travel again, and I wish to see if something during the last 24 months is changing. But if I look on the last 5 years, I can say without any doubt that when we talk about data, we must consider 3 pillars. And these pillars are people, rules or regulation, and technologies. All of them are fundamental, and everyone needs the others. But people must be in the center. People come before technology and rules. And for example, rules or regulation must help people, but when we change, we must consider what is going to change when we change our perspective. What happens, for example, when from data subject we become data processor or data controllers? What happens, for example, to our fundamental rights or freedoms? And what about our duties? Every minute we spend on internet, we upload about 500 hours of video on YouTube. We post about 3.3 million Facebook posts, and we perform about 3.8 million Google searches. But have we ever wondered what actually happens to those all posts, tweets, and videos we post every day? We need rules. And from an European side, we are lucky. GDPR is the best fitting solution for our personal data. everyone is trying to copy, sometimes trying also to paste it. But if as a data subject, we see only our rights, as data controller, we try to avoid our duties. From the Italian side, I think that there are two main different kind of issues. The first one is culture about data protection. And the second one is that we see rules like a problem and not like an opportunity. GDPR radically changed the way we collect, share, and use data all around the world. GDPR is ambition, not complex. It should be improved, but nowadays is the best law on personal data protection in the world. We must work as entrepreneur, as advisor, as a customer of users on awareness. We must work on culture. We must think about opportunity instead of problems on data protection. And people come first. Technology later and later. We must know, for example, where our data is stored. This is our right. But we must consider also what are they doing with our data? What are the big companies doing with our data? And this is our duty. We must consider these things. This is our duty. Don't forget this. We must grow not only from our right perspective, for example, but we also must grow from our duties perspective. This is a challenge. It's not quite simple. This is a challenge and we must win. Thank you.
Thank you very much, Mr. Garibaldi. This is really interesting. Also, the three pillars, as you were mentioning them, the people, the rules, and the technology. And I think we will go into this a little bit more in the discussion, because I think it's a very interesting perspective to think about these recommendations and the rules more from the perspective of the people, but also of the companies, the SMEs that are dealing with them. And yeah, so let's go to that in the discussion with, as the final opening statement, I would like to hand over to Ms. Cécile Faridine to give us some more insights on how small companies and large companies deal with these data transfers. And yeah, Ms. Faridine, the floor is yours. Ms. Faridine, I cannot hear you yet. I don't know if the other speakers can hear you. No, I don't think we can hear you yet. Maybe there's an option to turn on the microphone in GoToMeeting, but maybe it's also a connection issue. Okay, let's try for another time, and then otherwise we first go into the discussion and then we will get back to you afterwards. Let's just see if the problem can be solved, and if not, I'm sure we'll solve it in the next few minutes. Yeah, I still cannot hear you. So maybe we move on with the discussion first, and then we come back to you afterwards. I hope that's okay. Apologies for that. I hope we solve the technical issue. I would like to start the discussion with a question to Mr. Gomez Navarro, because you have given a very, very good introduction of the differences now between the first set of recommendations and now the updated set of recommendations. It was really interesting to hear about the sources of information, and then, yeah, how these are specified in Annex 3. And then after the presentation by Ms. Senatore, who was also explaining that that this is something that SMEs have to look into, the impact assessments of data transfers. I was just wondering, do you think, if after hearing also the comments from the other speakers, do you think this is now, is this enough for SMEs? Like, are we going to be able, are SMEs really in a position to deal with data transfers in a sufficiently clear manner? Or do you see room for improvement? I mean, I also know that from your perspective at the European Data Protection Board, you have a broader concern, and not only SMEs, but I would just like to hear your view on that, and if you want to comment on anything else you heard from the other speakers.
Thank you, Annika. Well, indeed, SMEs, although the EDPB has many issues to examine in terms of the addressees of its guidance, it usually bears in mind the needs of SMEs. We are aware that big players with big law firms or legal counsel that can support them, but we are also aware of that the SMEs will often lack this, and this is why we try to adapt the style and the content of the recommendations as much as possible to their needs. This is in any case what we try to do with these recommendations in terms of the style we use, and also in terms of the details and how we describe each of these examples of supplementary measures and where they could be effective. Some law firms may already be aware of them. As a matter of fact, we drew inspiration from some measures that were already being applied out there in the market, but not necessarily SMEs. In terms of their needs, well, the updated SECs, they may provide them with a tool that is already updated and in accordance with the GDPR and with the Schrems II judgment. And as Laura rightly said, and it's relieving to see that this has been noticed, the new SECs and the recommendations are consistent with each other. And the recommendations can serve to complement the new draft SECs. So this, we already hope, already will provide SMEs with more legal certainty, where there may not be much, especially after the demise of the Privacy Shield decision. And then in terms of the recommendations, what they can do, besides being complementary to the SECs and being consistent with them, we try to make them, to have them providing as practical guidance as possible for SMEs on the steps this assessment would need to follow that Laura explained. And we also wish to clarify to exporters how supervisory authorities interpret the Schrems II judgment, and consequently what their expectations will be, the expectations of supervisory authorities on SMEs or on data exporters in general applying this judgment. So it's also about clarifying the EDPB's the supervisory authorities that are part of the EDPB's expectations on SMEs. And also it may help SMEs in the sense that by preparing these recommendations, which was a long process that involved many hours of discussion and analysis inside the EDPB and among its members, this preparation also led to a common understanding among supervisory authorities on the application, on the interpretation and application of the Schrems II judgment. So we believe that this common understanding that was reached can only help to contributing to a consistent enforcement across the European Economic Area of the Schrems II judgment by supervisory authorities. And this can only be, we believe, beneficial for SMEs. It's worth noting that these recommendations were adopted unanimously by the 31 supervisory authorities that are members to the EDPB. So this is something also that could be significant. Yeah.
So there's consensus here, and indeed, a uniform application is really important also for SMEs in general, to have a digital single market where the same rules apply. Yeah, I would like to hear if Ms. Senatori has some more recommendations given this complex setup that you explained. So you already went through the steps, but if I am, let's say I am an SME transferring data to other countries, now I learned about the different steps I have to follow, but I'm still not entirely sure who I can turn to for support. I would assume the authorities, the national authorities, But if you could elaborate a little bit more on the sort of practical aspects, what an SME should be doing, looking into, and also commenting on what Mr. Gomez Navarro has just said.
With pleasure. As I was anticipating before, the most important thing is, which is not easy at all alone, is understanding whether an SME is transferring data. So this implies that the company shall have control of the contract signed with data processors. If it is not the case, there should be a first step of understanding which are the data, the providers, for example, processing personal data, whether the contracts signed with them enabled the transfer of personal data extra EU. And if the contracts alone do not clarify this step, they are not adequate. They cannot be considered adequate. So the first step is a contractual, the analysis of the contracts of the SMEs with data processors. So understanding whether the contracts allow data transfer. If they allow it, the contracts shall map where the data are transferred. Because if we don't start from that, it won't be possible to do the following steps. So the first thing is understanding who transfers and where. Another important point is that also the contracts may provide for transfer also from the processor to its sub-processors. So this should be mapped as well in the data processing agreement with the providers. So I should know, for example, that I have a contract with a communication provider, that this communication provider has a sub-processor which has its servers in Singapore, for example. So I need to have control by means of using adequate DPAs, because that's the only way, adequate contracts with my processor. I need to understand where I transfer. Then I need to understand which are the legal bases and check they are valid, such as adequacy decision, as I was saying. And as for standard contractual clause, the most difficult part is the step 3, which is very, very challenging. And to answer your question, as I agree with your initial statement, and I also agree with the answer of Mr. Gomez, of course, the steps and the suggestions made by the ADPB and also embedded in the standard contractual clause are necessary to be able to do this assessment for SMEs. But I'm not sure they are sufficient at the moment, which means that actually the assessment of the level of protection of the third country, it's something very complicated. And we are experiencing it with our clients and with big companies, for example, which have more means, also in terms of legal firms supporting them. A way of assessing this level of protection could be, for example, engaging a consultant in the country where the data are transferred, in order to have him assess the level of protection of the legislation, because it is not sure that the company or the SMEs, of course, knows the legislations of all the countries where the data could be transferred. Is something very complicated, because not only do you have to know all the legislation, but also practices applying to the services you are contractualizing, negotiating. So it is something not easy when it comes to, for example, communication services, and when it comes to known countries such as the European, the US. It is possible to, it is easy to find a company who already have done this assessment, but when it comes to other countries, it's very complicated. So I would, would we as players acting, supporting companies are experiencing every day, is that companies, especially the small ones and the SMEs, still need guidance, such as, for example, tool. We hope that one day that there could be tools to support the data transfer impact assessment, such as checklist, which could be used by SMEs in order to assess this legislation, for example, or we imagine cooperating with the data protection authority of the third countries in order to have an overview of the applicable legislation and practices, which could be applicable, let's say, to the different services, because we still lack, we believe with the companies, the data exporters, still lack means to do this complicated assessment, even though, because the assessment needs to be done on a subjective evaluation by the data exporter, but that needs to be demonstrated. And the third, last but not least, it's the principle of accountability. The GDPR leaves the data exporter to be able to demonstrate the reasoning that put him towards his final decision. So it is very important, even though the evaluation might not be perfect, it is very important to motivate it and to be able to demonstrate why the company defined that this transfer could be done. So it is important to leave a trace of the reasoning made, and that's something that also big companies are not accustomed to doing. So that's something not easy to be done in the everyday practice of the companies.
Thank you very much for this overview. So yes, it's very good. So I noted first, one of the hurdles SMEs need to actually be able to understand where they are transferring data and like to map their contracts with other partners. And then the other challenge is the impact assessment, where out of naive, if I was to be very naive, it's probably a very naive question, but I'm also wondering, indeed, having an overview of all the different countries and the situation there is quite challenging for a small company. So I'm just wondering if there couldn't be a smarter way to do this that would not put the burden on the SMEs, but there would be a sort of central authority taking care of this mapping and mapping this out.
I would say you're completely right, and that's what happens with the adequacy decision, actually, because when it's the commission that does this exercise, we have an adequacy decision. So as Mr. Gomez said before, of course, the most difficult thing is where the legislation is a complicated one, and we should see whether it is applicable or not, because the adequacy decisions still do that. They still look at the situation on the whole, and the commission tells us whether the level of protection is adequate or not. So that's already the tool that the GDPR thought about, is the adequacy decision. But when it comes to the different slightly legislation, the paradox, if I may call it so, is that the data exporters are called to assess something which is very complicated to be assessed also by the policymakers, by the commission, by the data protection authority. So the assessment that the data exporters are called to make, it's a very complicated one.
All right, thank you very much for the clarification. Let's try again with Ms. Faradin, if maybe the microphone works now, because I'm sure she would have many comments on this as well. I can see that you are, your microphone is on, but I still cannot hear you. I'm not sure what the issue could be, but I cannot hear you. All right, let's try again a bit later. And I would like to go back to Mr. Garibaldi, because when Mr. Gomez Navarro was also mentioning the consultation on the recommendations, where Asintel had actually also provided feedback. And I was wondering if you could elaborate a little bit on your ideas that you brought into the consultation, and if what you see, what you think, is the good way forward. Mr. Garibaldi.
Well, first of all, let me say that Asintel, as the Italian Business Association of ICT and Digital Companies, strongly believe that on behalf of the company it represents, its comment on the subject matter should be submitted and taken into account as an opportunity. We worked in the light of the measure laid down by the recommendation and taking into account in what the Italian Data Protection Authority stated a few months ago, recognizing, of course, the wider scope of the EDPB norm, which would be involved any third country whose regulatory system is not considered by the European Commission as able to offer a level of personal data protection equivalent to the European one. Also, it's quite fairly clear that there is a misalignment between the European Union and the United States or as third other country regulatory systems. This misalignment must be solved, of course, through adjustment at a regulatory level. And this is a complex situation, not easy to solve. But we strongly believe that, for example, a focus on encryption should be essential to ensure a baseline level of data protection and security. Now, more than ever, in order to avoid unlawful access and at the same time allow companies to transfer data to third countries, it is of the utmost importance to develop a system that guarantees upstream encryption. Encryption is not the only solution, but should be considered the easiest solution to apply quite just in time, for example. Encryption can help to protect data you send, receive, and of course you store using a device. That can include, for example, text messages stored in our smartphones, running logs saved in our fitness watch, or banking account or information sent through our online account. Encryption is a process. It's the process that scrambles readable text so that it can only be read by the person who had a secret code or a decryption key. It helps to provide data security for sensitive information. A lot of personal information are managed online and stored in the cloud or on server. And it's nearly impossible to do business of any kind without your personal data ended up in an organization network and computer system, which is the important thing to know to help to keep the data private. Encryption, I think that plays an essential role on data protection. There are several types of encryption. Each one is developed with different needs and security needs. Without going deeper, we should, for example, consider two kinds of encryption, the symmetric one and the asymmetric one. An asymmetric encryption that uses two keys for encryption and decryption. One is a public key, which is shared among users and encrypts data. And the other one that is a private key, which is not shared, decrypts the data. In case third countries, authorities request access to data store in their territory or by their companies, they can send, for example, a request to the European authority who can evaluate if this request is lawful, and guaranteeing a strong decryption system, you can transfer those data from those different countries. I'm sure that this should not be considered a long-term solution, but I think that encryption should be a good starting point. And this is how we worked about this suggestion.
Thank you so much, Mr. Garibaldi. This is very interesting, the point on encryption, because if I understand from a layperson perspective, it would actually mean that even though you transfer the data, then no one that doesn't have the authorization to access it could access it. So it's a good way of making sure that data protection and privacy is actually maintained. So I think it's really, really interesting to bring in this perspective. I would like to go back to Mr. Gomez Navarro, and I would like to hear a little bit your views, probably not on an official capacity, but more personally, what you think about the sort of international environment in terms of data protection and privacy, how this is evolving. We see a lot of well, different cultures and different approaches to data protection and privacy around the world. And I think even Max Schrems himself said that while he does believe that his actions before the Europe, like the courts in Europe, are important, he still believes that it would be much more beneficial if at some point the sort of culture and practices of data protection and privacy would converge between the US and the EU, for instance, because if we had similar values and practices and laws, then this would be much more beneficial to citizens than than making transfers more complicated. So I'm wondering how you see this sort of international dimension and the way forward here. And if you want, of course, you can also comment on the topic of encryption going forward.
Thank you for your question, which can be a complicated one, and I'll try to answer it. So in terms of the Schrems II judgment, for instance, which is seen by some as a breakthrough decision or something almost unexpected, more, in my personal view, more than a breakthrough, was a wake-up call, because this principle, this precautionary approach that the GDPR follows to transfers, whereby transfers to third countries outside the EEA can only take place if an essentially equivalent level of protection can be guaranteed. This already existed 26 years ago when the Directive 95 was adopted. The principle was already there. It is just that with this new string of judgments, recent string of judgments from the Court of Justice of the European Union and decisions from supervisory authorities, and also with the new enforcement powers given by the GDPR to supervisory authorities, the consequences of this principle, the practical effects, are becoming materialized now. In terms of, in a wider global context, I think there are several trends that are noteworthy. First, citizens are becoming increasingly aware and educated on the risk in relation to the processing of their personal data. And as a consequence, they are becoming more demanding with respect to this risk, and rightly so, in terms of the guarantees over the processing of their personal data. This is not only limited to citizens. Governments around the world are also becoming aware of the risk involved in relation to the processing of data in third countries. And as Davide mentioned before, they are adopting laws that are very similar to the GDPR. And this is not only out of concern of being able to trade with the European Union. This is also out of concern for their own citizens and for their own interest. Recently, we saw the President Biden, for instance, issuing an executive order checking on the processing of data of apps in what they call foreign adversaries or countries. So this is not a concern that is limited to Europe. This is also a concern that is being shared and that is being seen everywhere. So in terms of the specific consequences, effects this may have for SMEs, I think it's necessary to distinguish. Here again, I'm speaking on my personal behalf, my personal view, and based on my experience also. Before joining the DPV, I worked in Interpol for 8 years, dealing with the processing of police data around the world in all 194 member countries of Interpol. So I also have this perspective of the controller and dealing with very global and diverse situations. So I think that in terms of in the short term, it will certainly be complicated for SMEs to implement all these steps and to evaluate their transfers and to act accordingly. This is for certain, and will necessarily require more resources and investment from their part, and will probably raise their cost. I would personally hope for them that they obtain help not only from us, but also from other associations, public bodies, and others to carry out these assessments. Investment agencies, chambers of commerce, associations, that they facilitate their task also to them. However, in a more positive note, and as Davide mentioned before, I thought it was very interesting, in the medium to long term, as it's usually said, necessity is the mother of invention. So I foresee that SMEs will be given more options by big service providers, for instance, that may offer them options that are more privacy compliant. So this will increase the market they have at their disposal. We are already seeing an increase in the terms of innovation, in terms of encryption. I was mentioned before, different types of encryption, pseudonymization, and other techniques that may help protect the security of the data. And also, as I mentioned before, citizens are becoming increasingly demanding in terms of safeguards and guarantees on the protection of their personal data. And for the SMEs that seek to be compliant with the very high level of protection that you find in the EU, I think this can only give them an edge in the future over other companies that would not be compliant with these regulatory requirements. And finally, as it was also mentioned before, indeed, the Schrems II judgment and all the consequences and the legal certainty that has derived has prompted discussions across the Atlantic and also amongst the like-minded countries. We are seeing them, for instance, at the OECD, on an initiative launched by Japan that is called Trusted Government Access, to reach common global standards, not only on data protection, but also on government access to data, on what may be acceptable and what may not be acceptable. So in the medium to long term, we may see a wider convergence, at least among like-minded countries in this respect, which can only again be beneficial for SMEs. Although I'm afraid we'll have to wait for the mid or long term before seeing this. Thank you.
Very much. We have a couple of questions from the audience, but I would still like to give Cecile the opportunity to try again. I hope maybe it works now.
I've switched microphones.
Yes, it's working.
Wonderful. I think it's.
Yeah, I'm sorry. Yeah. Okay, please go ahead. We are a bit. So yeah, please go ahead. Thank you.
So I'll just talk about what I had planned for the introduction. I think some of the topics have already been mentioned, and unfortunately I missed part of the conversation. But as you mentioned earlier, I do work for a company which is the external data protection officer for a number of German and European companies, and we have our smallest client has just 17 employees, and the largest has over 40,000. Which gives me quite a good opportunity to see the difference in implementation of data protection for small and medium companies compared to large companies. And there are two elements which particularly jump out. So it's for one thing, the comparison between those, simply in terms of staff availability, in that to transfer data to third countries in large companies, there is a large legal department. There are often even subsidiaries in various countries, or people who at least know the language or have abilities in that regard, which of course enables them to do the assessment much easier, both the legal part and also to check in practice, because they have the time and the capacity, whereas small and medium companies are more restricted in that regard, because there is sometimes just one person in the department, there is no subsidiary there or no knowledge of the language. And it is something that I also saw with one of my clients the other way around. They had to transfer data from China, which also of course has a very specific data protection law. I have my opinions on it, but that's not the topic. But it was really restricted to having someone who knows Chinese to be able to give the information about how to do this. And the same applies also the other way around. And another point, which Mr. Gomez has just pretty much answered, and which I had already also planned on mentioning, is the difference in balance between SMEs and large companies on the market, especially tech companies, when they want to have access to those services. They often do not have the possibility to negotiate or to have different terms. They simply have to accept what is given to them. And in some cases, they don't even get answers to the questions they ask. And for example, something that happened to me a week ago, an American server provider with servers in Frankfurt ensured in the DPA that the data would not leave the European Union, but there were ESCCs attached to the DPA. And we never got an answer to the question, why is there an ESCC if the data does not leave the EU? Why is it necessary? Can you explain to us where the data will go if you need an ESCC? And we never got an answer to that. So we simply have to accept it as such, or try to find another provider, which is also difficult. But I do think, to conclude, that the new ESCCs have significantly simplified the situation for SMEs because it's already included in the new clauses, part of the assessment, and it's definitely a step forward and has included many questions that since July and until now we had to deal with on our own. Thank you.
Thank you so much for giving these practical examples. And I mean, also the language question, it's of course something very practical, but that may not be very obvious when we talk about this topic. We have a couple of questions from the audience that I would like to give the opportunity to participants to ask directly. To my colleague Rosanna, can we give the floor to Ms. Silvana Makutuli to ask her question?
Hello.
I'm not. Hello. Yeah.
Can you hear me?
We can hear you. Thank you. You had a question in the chat, and I thought maybe do you want to ask the question directly?
Oh, yes, thank you. My name is Silvana Marcotulli. I'm an international business lawyer and specialize in corporate and IP law. And I'm one of the co-chair of the working group on Digital SMEs Alliance. I have a question to Mr. Garibaldi, as if in his experience as an entrepreneur and also as advisor and with the association, if the SMEs are aware of the risk, I mean, or they maybe consider this issue in the risk management, but because maybe Mr. Garibaldi is more aware than the other participants that there is a law now in Italy that we have to consider, I mean, the company have to consider all the risk, and also the accountant or the advisor, maybe they made a report on these on this. So this is one of the questions for Mr. Garibaldi. And another question is for Mr. Navarro. He has already answered in a certain way. And also Annika raised this question. As you know, for the SMEs or for the citizens, it's quite not impossible, but very difficult, because when I have a software or just put an app, an application on my phone, on my mobile phone, I just subscribe a license without know the condition. So why don't put the obligation to the big player and not for the SMEs? So you have to ensure the SMEs and the company and the citizens that you are in line with our
okay. Thank you, Silvana. I think we can give the floor to. Sorry, I think I just had a small connection issue because I couldn't hear the end of your question. But if Mr. Garibaldi could maybe already answer the first part, and then we can. I think the second part was addressed to Mr. Gomez Navarro.
Okay, but well, I think that awareness is a big issue, especially for small medium enterprises, but also for us like people or user or consumers. Working on awareness is a duty for everyone who's doing my job. I think that we should change our approach to, for example, to risk management. But if we think only about the Italian situation, and if we think how many Italian companies have a chief information security officer, and only a very little number of that has a chief information security officer, this is the only way to answer. Awareness. Risk management and enterprise risk management, it comes around awareness. I think that we must do a lot of things before arriving to a risk approach culture in Italy, and we should start from awareness.
Okay. Thank you so much. So awareness. These three words, definitely. Mr. Nicolas Kotas also had two questions. Maybe we can also invite him to take the floor.
Questions have maybe to do with how realistic it is for a small company to do all the assessment, to do the assessment of a third country. For example, we are a technology software company based in the EU, and we have customers from all over the world using our software. So, you know, in many cases, we will have to do these assessments. But as you understand, we don't have, we cannot hire a developer to do these assessments for us. And it's quite...
I think the connections...
Yes. Can you hear me? Okay, great. Yeah, so we are afraid...
Now it's better, yes.
Yeah, we're afraid there is a big risk that we're not going to be able to do the assessments properly. So really, how realistic and how costly could be this for a small company that does not have an internal big legal department? And how, I think Mr. Gomez mentioned at some point that companies can ask different organizations for help. But again, what would this cost, and what would this mean for a small company in terms of time, in terms of work that needs to be done? And if you believe that this is something that it's realistic for, especially for small companies, we're 15 people, mainly developers, and a couple of us are business people. So yeah, that. And thank you.
Thank you very much for this very practical testimony from an SME. I guess, yeah, like you have 15 companies working on development, you don't have a legal department, and now you have to deal with this third-party assessments. I think, yeah.
Small companies usually have like external legal consultants, part-time basically legal consultants. So how realistic it is for us to actually go through and do an assessment of a few third countries for the data transfers?
Thank you very much for your question. Yes, so I think, well, anyone can jump in, but if Mr. Gomez Navarro would like to start, or otherwise Ms. Salvatore or
yes.
Ms. Faverdine, please go
Yes,
ahead.
I may also take the opportunity to try to answer the question that was made before on the imbalance of powers of negotiation. Well, here, of course, the EDPB must always follow the GDPR, but also the case law of the European Court of Justice. And the European Court of Justice repeatedly says across its judgment that it is the responsibility of the data exporter to conduct this assessment, and then adds, where appropriate, in collaboration with the data importer. As you may have seen in the recommendations themselves, a lot of emphasis is placed also on the role that the data importer must play in cooperating with the data exporter and facilitating this assessment. And even some supplementary measures are suggested to increase the liability or the responsibility of the data importer vis-a-vis the data exporter with regard to this assessment. And this is also that you may have also seen in the new SECs. More specifically, if you look at clause 14, we're not talking about only the responsibility of the exporter, we are talking about the parties together warranting that the level of protection can be ensured. And there's even a clause in paragraph C that says that the data importer warrants that in carrying out this assessment, he has made its best efforts, so it's a very high standard of conduct already, best efforts, to provide the data exporter with relevant information, and agrees that it will continue cooperating with the data exporter. So although the judgment does say that it's primarily the responsibility of the data exporter, whether it is a controller or a processor, because as you know, both may act as data exporter in different situations, it increases the SECs and the recommendations. They also put try to increase the responsibility of data importers in helping with this assessment. And this could, of course, naturally involve big data service providers. And so I hope this answered more or less the first question. As for the second one, of course, we fully understand how complicated this assessment can be. Although again, indeed, the court does say that the primary responsibility for carrying out this assessment lies on the data exporter, regardless of its size, regardless of the data exporter, whenever it decides to transfer data outside the EEA, the European Economic Area, must fulfill this responsibility that derives from the principle of accountability of the GDPR, of evaluating that the data transfer is secure, is up to the required standard. Now, in more practical terms, how could this be done? The EDPB, the recommendations are only one piece of the guidance that the EDPB is trying to come up to help exporters. There are also the recommendations on the European essential guarantees for surveillance measures that provide some elements. There were also recently guidelines on Article 23 of the GDPR on the exceptions may find. And there will be in the future more specific guidance also on matters relevant to the Schrems II judgment in relation to this. Now, as some suggest often, can the EDPB make some sort of adequacy decisions over third countries? So it's questionable, and this is my personal view, first, that it has the mandate, because as you know, the mandate of doing adequacy decisions lies with the European Commission. Second, in this specific assessment, we are not talking about country-wide assessments, but we are talking about assessment of a very specific transfer to a very specific country, which could be one of the 150 countries around the world that do not have, are not members of the EU or do not have adequacy assessments. So it's even questionable that the EDPB will have the resources to carry these types of assessments. Some supervisory authorities, in the end, they have the same, if not less, resources than many financial and human resources than many SMEs. So for them, it will also be a challenge to carry out this assessment. Because as you know, the court said that primarily is the responsibility of the data exporter, but subsidiarily, it is the responsibility of supervisory authorities to carry out this assessment and to suspend the transfers where the level of protection is not being complied with, and to adopt any other appropriate measures. This is why, and this is my personal view, SMEs will not be able to rely only on the EDPB, but I hope that they will be able to rely on whether it's public bodies, chambers of commerce that they may have in their countries, trade, investment, and agencies. As you know, there are public agencies promoting the exports of their country's companies or other types of public bodies, because I would say that it is mainly the governments of the exporting countries that have the biggest wealth of information of what the situation is in third countries, and also potentially that they will be able to mutualize these efforts via SMEs associations or others in specific sectors. But these are just ideas, although some of these sources are mentioned indeed in Annex 3 of the recommendation supplementary measures. Thank you.
Okay, thank you so much for this comprehensive answer. I think it's really useful. Let me check if there are more questions in the chat, and if Ms. Senatori or Ms. Faridin still wanted to comment on any of the questions.
If there are no other questions, I had some observations also with reference to the last questions. The last question shared with Mr. Gomez concerning the costs and the feasibility of this assessment for SMEs. I can completely see the point of the speaker who asked of the participant who asked this question. My apologies, I don't remember the name because I couldn't hear very well. But that's exactly the kind of question that our clients ask us very often, because the point is that, of course, at the moment, without the help of a legal consultant or a legal expert, it is actually complicated to do this assessment, this data impact assessment, and assessing the level of protection of the third country. It is complicated to do it on its own because it requires expertise, it requires competencies, it requires knowledge of the laws. So on the one, our very basic and practical suggestion is to consider this when choosing a provider. So a good thing is, if you're not able to sustain the costs of understanding whether data can be lawfully transferred, you could consider choosing at the very beginning of the negotiation, choosing a provider which does not transfer personal data outside EU. Because another thing to consider, which Mr. Gomez also underlined before, is that the market is moving towards this revolution of personal data. And this is very true with reference to service provider. So also from what Mr. Giribaldi said before, privacy is of course an effort for many companies, but for others it's an opportunity. So for other companies, it is important to allocate themselves on the marketplace in consideration of their ability to allow their clients to satisfy the obligation of the GDPR, which means that from the very beginning of the choice of the provider that you could, for example, use in your services, you shall consider that. So, for example, you could consider choosing a provider that does not transfer, or a provider that has a lot of documentation online, assessing, for example, supplementary measures or security measures that do not impeach the effectiveness of the standard contractual clause. So there are providers that are moving towards this direction, and that's one hope. So your counterparty can be one hope, and another hope can be the data protection authorities, because in this extremely changeable say landscape, the data protection authorities have an important role, and they have been very useful to SMEs in past. We can consider tools and toolkit made available to SMEs from ICO, from the Spanish data protection authorities. So we hope that the data protection authority can make a step towards SMEs to help them in this complicated assessment. So we will let you know in case you know anything on that.
Thank you very much, Ms. Senator. It's really interesting also your point in terms of the shift of the market and this orientation towards data protection, privacy-friendly offers. I would like to give the opportunity to Mr. Giribaldi and Ms. Faridin to say, to have a short 1-minute statement at the end of this discussion, because we already reached our time limit, and then we will close it. Mr. Giribaldi, would you like to add something?
Yes. Just one little thing. I totally agree with what Laura said, but I wish to add only a little point. Please do not consider privacy or data protection assessment or risk only from a legal point of view. It's not only a legal problem, it's a people problem and then a technological problem. Every day when I talk with my customer, they start from a legal point of view, and this is correct. But we must go more in deep, talking with people and listening and try to understanding what is the level of technology. Thanks.
Thank you very much. Ms. Faverdine. I think there's an issue with the connection because I only see a frozen image. Yes, I think we've reached the end of this discussion, and I would like to close it here. I would like to thank very, very much the speakers who have provided very valuable insights. And it was really interesting for us, for myself personally, but also for the audience. We will certainly try to make a sort of summary of what has been discussed to give some more guidance to the SMEs in the audience on how to navigate in this area, how to move forward. And yeah, with this, I would like to close this session of Digital SME Live on Schrems II and data transfers. Thank you very much to the speakers, and I look forward to being in touch with you in the future. Goodbye.
Thank you. Goodbye.
Bye-bye.